Guys, welcome back to my channel When Humanities is Life. Today in this video we will be starting with the chapter on judiciary. It's the last chapter in your syllabus. Now let me tell you what is there in your syllabus. Now this syllabus is provided by CBSC. I've taken it from the official website. You can go check it out. This video is on judiciary, and today in this video we will be covering part 1, constitutional roles and impartiality, hierarchy of the courts, and the structure of the civil court. There are two more topics left: criminal courts and other courts, and we will be covering it the next day in the next video. The entire chapter on judiciary is there. And with regard to the family justice system, one of you wrote in the comments that why didn't I make a video on the rest of the parts. Well, the parts on children and juvenile justice, those are not there in your syllabus. It's clearly mentioned that only these four parts: introduction, institutional framework, marriage and divorce, and domestic violence is there. Both these chapters are of 20 marks, and 10 marks is on projects, so the total marks is 50. Okay, I hope there's no confusion regarding the syllabus anymore. So let's start the chapter on judiciary. We know that there are three organs of the government: the executive, the legislature, and the judiciary. Now, judiciary consists of all the courts: the Supreme Court, the High Court, and a system of subordinate courts below the High Court. And it's all about the legal system, it's all about law. Alright, the legal system in India, the Indian legal system, it derives its authority from where? From the Indian Constitution. You have read about the Constitution in detail in term 1, if I am not wrong. So, the judiciary, it substantiates the separation of powers between the three organs of the government, as I mentioned: executive, legislature, and the judiciary. And it also safeguards the interest of the Indian citizens by not allowing the other organs, namely the executive and the judiciary and the legislature, to abuse power. Okay, it shouldn't go beyond the roles assigned to them in the constitution. By preventing them from doing it, the judiciary safeguards our interests. Now, when we talk about judiciary, the first thing that comes to our mind is the Supreme Court, the apex of all the courts in India, the central body. It's the logical and the primary custodian of the Indian constitution. It ensures that all the other organs of the government, it performs its duties in the government, and it's the final authority in interpreting the legal issues and the constitutional arrangements. Alright, it has the final say in every dispute that arises in our country. It says final. It also examines the validity of the constitutional amendments by the process known as judicial review. We will know what it is. Actually, it's a procedure by which it strikes down any legislation as invalid if it's not in accordance with the principles embodied in the Indian Constitution. It's a power granted to the Supreme Court, and it's inalienable. It has to follow it. Okay? We come to the next part: constitution, roles, and impartiality. The Indian judicial system, let me tell you, it's an extension of the British legal system. When the British came to India, it established many institutions, including the courts in Calcutta, Bombay, Madras, and we have been following these courts throughout these years. The adversarial system, you will read in details in the next class, in class 12. We follow the adversarial system. We follow these codes that were established by the British, and as a result, a substantial part of what we follow today are those institutions that were established by the British back then in the 18th and the 19th centuries. Now, the Supreme Court, whenever I write SC, you will know that it's Supreme Court. Whenever I write HC, it's High Courts. Okay, we will see this throughout the video now. Now, the Supreme Court is the apex of all the courts in India. followed by the 24 high courts. Now, in your textbook, it's written 24, but let me update you. It's actually 25 now, with Telangana and all. And below the high courts, we have the district courts, a system of subordinate courts, as we call it. It supervise and govern the numerous district courts below it, the Supreme Court and the high courts. Now, in this state, we are introduced to two different articles, Article 129 and Article 141. I will tell you which articles to learn and which articles not to learn, but I must tell you these two articles are important, so you should learn it. It's very easy, once you read it once, perhaps you will read the chapter 2 or 3 times and you will get all these articles. Now, the Supreme Court, this article states the Supreme Court is a court of record. In the book, it's not explained what does it mean. Let me tell you what it means. First of all, from the name, you will remember that all the cases that are fought in the Supreme Court, they are the records of all these cases are maintained meticulously. This point is not mentioned anywhere, but that's how the court of record, this expression emerges. So that's the first point. Now, then the most important point is that all the decisions given by the Supreme Court, rendered by the Supreme Court, they are accepted by all the other courts in India, all courts within the territory of India. And the verdict of the Supreme Court, all those verdicts are accepted by all the courts in India. The judgment given by the Supreme Courts, they are treated as law. And the Supreme Court can also alter, change, or modify its decisions. That's why Supreme Court is called a court of record. And which article provides this? Article 129. Now, high courts are also court of record. We will see that in a few minutes. And there is another article, Article 141. This article states that the laws declared by the Supreme Court is binding on all subordinate courts in India. We come to the next portion of judiciary. This chapter is all about judiciary. Now, judiciary, it interprets and applies different laws that are enacted by the legislature, as well as laws that are made by the decisions of the courts within the judiciary. The important roles, we are discussing the important roles of the judiciary here. First of all, it interprets and applies laws. Then it adjudicates the different controversies between the citizens or between the states and the various other parties. Then its main duty is to uphold the rule of law in the country, and it also safeguards the civil and political rights of the citizens, as well as the supremacy of the constitution. In India, constitution is supreme. In any country, in any developed country, the constitution is supreme. Primarily, the Supreme Court settles disputes by exercising jurisdiction over 3 areas: original jurisdiction, advisory jurisdiction, and appellate jurisdiction. Now, original jurisdiction, we will discuss it right now. Original, as the name suggests, there are many disputes that can be directly brought to the Supreme Court. In general, whenever we are engaging in a dispute with someone at a very basic level, we do not directly go to the Supreme Court. You will notice that people generally approach the lowest courts. In a civil case, we approach the Municipal Court. In a criminal case, perhaps the Sessions Court, or even lower, the second class Judicial Magistrate Court, etc. So, in these regards, we approach the lowest courts. But there are certain disputes in the country that can be directly taken to the Supreme Court. Those disputes are called original. Those disputes fall within the original jurisdiction. For example, disputes between states, disputes between the center and the states over sharing of river waters is a very basic example. Then advisory jurisdiction, it's an area of law and debates where the President of India can seek the advice of Supreme Court with regard to various issues of national importance, which involves public welfare. And third jurisdiction is the appellate jurisdiction. As the name suggests, it comes from the word appeal. Appellate jurisdiction, as in perhaps there is a judgment given by the High Court, and the party is not accepting that very decision. Perhaps a person who has been given a death sentence, like a terrorist or someone else, perhaps, he or she can approach the Supreme Court. He can plead the Supreme Court that please reverse this order. This order is very disproportionate and burdensome. In such cases, the Supreme Court may change the order of the High Court. It has the power to do so, but obviously it will decide whether it's just or not. Obviously, a person who has murdered, a terrorist, or a rapist, the person shouldn't be acquitted just because he is appealing to the Supreme Court. Such things are there. So we first discuss the original jurisdiction in detail, as it's there in the textbook. Now the Supreme Court decides controversies between the different states and between the center and the states. And in most of these cases, the issue is regarding the distribution of power and function between the center and the state. Obviously, disputes arise because of powers and functions. Now, judiciary is made the watchdog. It watches and guards the Indian democracy. It examines the constitutionality of legislation. When laws and enactments are passed, then whether such laws are in accordance to the constitution, it is decided by the judiciary. Now, it primarily follows three principles with regard to deciding the validity of legislation. First of all, doctrine of pith and substance, then doctrine of severability, and then doctrine of colorable legislation. Now, you must understand these three concepts very well because it's not clear in the textbook. First of all, doctrine of pith and substance. What does it state? It states that the true object of a statute or a legislation has to be understood with respect to the competence of the legislature which has legislated it. What does it mean? Suppose the central government, the union government, it enacts a law with respect to the topic on police. Now, you must be knowing about the three lists of the Indian Constitution. It's there in the 7th schedule: the union list, the state list, and the concurrent list. Now, there are certain things in the union list on which only the union government can make laws. Similarly, there are certain things in the state list on which only the state government can make laws, and obviously in the concurrent list there are things on which both the state and the center can make laws. Alright. Now, if the central government make law on something which is there in the state list, for example, the topic on police is there in the state list. In that respect, no matter what the law states, no matter how noble the law is, it cannot be considered valid because the legislature which enacted it is not competent enough to legislate on the topic. So, doctrine of pith and substance will invalidate, will declare null and void any such law made by the union government on a topic which goes beyond its competence. That's all about the doctrine of pith and substance. Now, this is what is written in your textbook. There is nothing more to explain. If you are still not clear, you can take the help of any other source like the internet or whatever. I don't think you will need anything else. And don't give this example of the three list because it's not there in your textbook. Then the doctrine of severability. Now, this doctrine, it separates the repugnant provisions, the void provisions of a statute or law from others that are constitutional. Now, those provisions which are repugnant or void, the violating portions, they are declared void to the extent of the inconsistency, and the remaining portions which are valid, which are not void, they remains valid, they remain enforceable. This is the doctrine of severability. Only those portions which are void, they are separated. The others remain potent. And the third doctrine is the doctrine of colorable legislation. You cannot do indirectly what you cannot do directly. Alright, what does it mean? This is the maxim that makes this concept clear. Doctrine of colorable legislation. Something is colored, something is made unclear, something is hidden. It prevents the legislature from making laws that they would otherwise not be able to make, keeping in mind the constitutional constraints. Sometimes they make laws indirectly, which will suit their interest. The judiciary, in such cases, through judicial review, will invalidate it by using this doctrine that you cannot make law which is so indirect, because you would have not been able to do it clearly, directly. Now you're doing it indirectly, so it's not valid. That's what the doctrine of colorable legislation is. Now, okay, in this respect, I will introduce you to Article 368 of the Constitution, which gives the Parliament the power to legislate. It gives the procedure that the Parliament has to follow in order to make a law. And now we come to the basic structure. But mind you, this is the most beautiful part of legal studies. I think it's a wonderful creation by the Supreme Court of India. Okay, let's see what does it say. Okay, the basic structure. This phrase was introduced in the Golaknath versus State of Punjab case, and it was applied more profoundly in the Keshavananda Bharati versus State of Kerala case of 1970. There will be a Bharati here. I missed it. Okay, what does it? What does the doctrine of basic structure say? It states that any amendment which aims at abrogating or changing the basic structure of the constitution, it would be unconstitutional. The parliament, by using article 368, it cannot violate those portions which are there in the basic structure. It can change any portion of the constitution. Such provisions are made by article 368, but it cannot change the basic structure. And the basic structure primarily consists of six elements. First of all, supremacy of the Indian constitution. The constitution is supreme, as I said. That's what the judiciary protects too. Then the republican and democratic form of the government, the secular nature of the constitution, judicial review as a power of the Supreme Court. Okay, this is a very important feature of the basic structure, and it was included in the basic structure just to prevent the other two organs from abusing power. Then the separation of power between the three organs of the government, legislature, executive, and the judiciary. And finally, the federal distribution of power, the federal character of the constitution, the distribution of power between the center and the state. Okay, now this case, you will come back to this case again and again in your legal studies course, the school level, in your college, whatever, because this is a beautiful part of the history of Indian legal practice. In this case, there was a history. I'm just introducing you a little bit. What happened? It was during the emergency of 1975 that the country was going through a tumultuous time, and the parliament, by using article 368, it started violating the fundamental rights of the citizens. With this respect, cases were brought to the Supreme Court. Keshavananda was a priest actually in Kerala, and his right to property was being taken. In a series of historical decisions by the Supreme Court, it was later decided that okay, fundamental rights won't be a part of the basic structure, but it had established certain restrictions on the parliament's law enacting powers, and it had established this doctrine of basic structure. The parliament cannot abrogate the basic structure. Anything that is against the basic structure on these features, secularism or supremacy of the constitution, or against democracy, it's invalid. And this will be declared how? Through judicial review by the courts, by the Supreme Court. Judicial review, I think you are clear about this now. Let me re-explain. It is by judicial review that the Supreme Court, it examines the validity of a particular law or an enactment, if it's in accordance to the constitution or not. That's judicial review. By this, it can change or it can invalidate, it can nullify any legislation. Then the last part here. Now, the Supreme Court, by judicial scrutiny, can strike down any piece of legislation on two grounds. If Article 368, as we just learned here, it's a law enacting power of the Parliament. If the procedure provided in Article 368 is not followed, it can be struck down, or if it violates the basic structure, as I said. Right? We come to the next part. The writ jurisdiction of the Supreme Court. It can be invoked by Article 32 of the Indian Constitution. Now, writ jurisdiction of the Supreme Court, Article 32, and writ jurisdiction of the High Court, Article 226. Repeat this again and again. 32 for Supreme Court, 226 for High Court. Now, it is by this writ jurisdiction that the Supreme Court can issue writs. Writs are orders issued by the Supreme Court or the High Court. It declares a law null and void if it encroaches upon the rights or the fundamental rights, more specifically, of the citizens. There are many writs like habeas corpus, which translates to you may have the body, or mandamus, certiorari, prohibition, quo warrant, or by what warrant. So all these writs are issued by the Supreme Court whenever a fundamental right of the citizen is being abused, is being violated. It's there in the box of page 146. You must read it. I didn't do it in details. That's what it is all about. You have to read it. And we come to PIL, the public interest litigation, which is also called SAL, social action litigation. In Hindi, it's called Janhit Yachika. Matters of public importance or public interest rather, it's brought before the Supreme Court. That is what is called judicial activism or the public interest litigation. And here we come to an end to the original jurisdiction of the Supreme Court. This is actually part of the writ jurisdiction. We form a different jurisdiction called writ jurisdiction. Then we come to appellate jurisdiction. I explained it in short before also. Appellate jurisdiction, well, appeal in constitutional matters, it is provided in Article 132, subclause 1. Appeal can lie from a judgment, decree, or final order of the High Court if it certifies that such an appeal is valid, if it is involved in a substantial question of law or interpretation of such laws, then only the Supreme Court will accept such appeal. Appellate jurisdiction is basically about appeals of cases from High Court. It's against the decision of the High Court when the High Court has passed a decision and perhaps the parties on whom the decision is being given, the party has not accepted the decision. They want a change or they want a better order. In that case, after the High Court, they will approach the Supreme Court. First of all, they will approach the lower courts. Then from the lower court to the subordinate courts, they will go to the district court. After the district court to the High Court. And after the High Court, the Supreme Court. Final authority is the Supreme Court. Okay, so that's in constitutional matters related to law and other such important statutes. And Article 132 is about constitutional matters, as I discussed. Article 133 is about civil cases. Appeal in civil cases will lie to the Supreme Court from, again, the judgment, decree, or final order of a High Court only if the High Court certifies under Article 134 Part A that the case involves a substantial question of law of general importance, and under Part B that in the opinion of the High Court, the Supreme Court needs to decide the question. There is something that is tricky, that can be changed, that should be interpreted in a different way by the Supreme Court. Then only the Supreme Court will accept if the High Court certify. And also in criminal cases, and that's given by Article 134, an appeal shall lie in the Supreme Court from any judgment, decree, or final order given by the High Court in a criminal proceeding. Now, this can be with or without a certificate. Okay, if the High Court, has an appeal reversed, or the order of acquittal is given to the accused person and sentenced him to death, or has withdrawn the person for trial before any case has been formed, in all those respects, appeals can lie to the Supreme Court. All right, we come to the next part, the advisory jurisdiction of the Supreme Court. What does it say? It can be invoked in two ways. First of all, if the President feels that there is a question of law or fact, or if the question is of public importance, and the opinion of the Supreme Court should be taken with respect to that. And it is regard to advisory jurisdiction that we may two important cases again. First of all, the Re-Kerala Education Bill case of 1958 and the Special Court Bill case of 1979. Let's do this case first. In this case, the Supreme Court stated that it can agree or it can refuse to give advice, and the president can also accept or reject the advice of the Supreme Court. It's not binding on the Supreme Court to give an advice to the president, and it's also not binding on the president to accept the advice that is given by the Supreme Court. In the next case of 1979, the advisory jurisdiction was made binding on all courts of India. Whatever advice will be given by the Supreme Court, it has to be followed by all courts in the territory of India. And it also stated that under Article 143, the Supreme Court is bound to give advice if the question of the president is not vague. The independence and impartiality of the Supreme Court. These two are the terms with respect to the institution of the Supreme Court as an important organ of the judiciary. First of all, independence doesn't only refer to a state of mind, it also regards to the status or relationship of the Supreme Court, particularly to the executive branch of the government, which includes the president, the prime minister, and the bureaucrats. And impartiality refers to the state of mind or attitude. To be impartial, impartial means the ability to take decisions without taking a side, to be neutral while taking decisions. That is the hallmark of justice. Now, India is a parliamentary democracy with a federal constitutional system where power is divided between the union and the state government or the provinces, as you will call it. And though India is federal, there is a line in this regard. The Indian government is federal in character and unitary in spirit. So it definitely gives powers to the provinces, but in practice, the constitution makers wanted the Indian government to be unitary. So the center should be strong. It shouldn't happen that the center is having no say. When the center is strong, the governance process as a whole, it can be very smooth. All right. So Dr. B.R. Ambedkar, who is called the chief architect of the Indian Constitution, he was the chairman of the Constitution Drafting Committee. He stated that India has one single integrated judiciary, and that's true. If you can say that with respect to government, the provinces have a lot of power, but with respect to judiciary, the Supreme Court is a final power. It can overrule the decisions of the High Court. You have just now read in the appellate jurisdiction. So, India has an unified judicial system. The Supreme Court is the apex institution. There are high courts below the Supreme Court, and below each high court, there is a system of subordinate courts. That's the 4 point here of what Dr. B.R. Ambedkar stated, and this is the most important part of this chapter. These 4 points, you should memorize it. Then we come to the next part, constitutional provisions regarding the appointment of a judge. All right. First of all, the article is 124, which deals with the appointment of a judge of the Supreme Court. First criteria is the person has to be the citizen of India to be a judge of the Supreme Court. Then he has been a judge of a high court or two or more such courts in succession for at least 5 years, or he or she has been an advocate of a high court or two or more such courts in succession for at least 10 years. And the last point, the person is a distinguished jurist. Jurist is a person who is very adept in law. The person is a scholar in law. So a person can also be the judge of the Supreme Court if he or she is a jurist in the opinion of the president. Now we come to the next part, provisions ensuring the independence of judiciary. First of all, the judges, they subscribe to an oath or affirmation. There is something in the court or even in the government that I thereby promise or something like that in a more formal way, that I will always put my effort into my job. Such an oath is taken to ensure that the judges will never break it, and they obviously give their best in the job. The second point is the security of tenure. The person cannot be removed except for impeachment. Impeachment is the formal procedure which is taken if the judge has, broken the code of conduct and has done something illegal and immoral, who has not performed the duty to the fullest extent possible. In such respect, the person is removed. And this is a very complicated process. This process kept complicated so that the person or the judge is never removed in an unfair manner. Obviously, the judges often give judgments in a democratic way against the government. If the government, suppose, infringes the rights upon people in an unfair way, which happened around 1975 in India, you should read it in the internet, or you'll read it in detail in the next year if you have political science. So, in such a respect, Supreme Court is an institution which has always been protecting the rights of the Indian citizens since time immemorial, since the government was established. That is the function of the Supreme Court. And often, when such decisions are taken, the government will try to dismiss those judges who are the main actors in judiciary. So, they cannot be removed by the government so easily. They can be removed only by proven misbehavior and incapacity. And the process of impeachment, as a result, has been kept very stringent. It's very complex and difficult. They can't be removed easily. Plus, they have a security of tenure with respect to the retirement age. They have a very high retirement age, 65 years for Supreme Court judges and 62 years for High Court judges. And their privileges, their allowances, and their perks or money, salary, these are protected by the Indian Constitution. The Consolidated Fund of India is used to pay the Supreme Court judges, and the Consolidated Fund of the state is used to pay the High Court judges. And they also have the power to punish for contempt. And lastly, their conduct is not subjected to discussion in parliament or any other floor of the executive or legislature. All these provisions ensures the independence of the judiciary. And the government of India, it proposed the Judges Standards and Accountability Act to introduce more accountability uh, in the judiciary. Alright, I am showing you a chart here which shows the hierarchy of the Indian legal system. At the apex, as I said, is the Supreme Court. Below the Supreme Court, we have the High Courts, and now we are looking into this. Okay, first of all, the metropolitan courts. What are the metropolitan courts? Those are the courts in a metropolitan city. There are 4 metropolitan cities in India, and any city which is designated as a metropolitan city by the governor, they have metropolitan courts. In the civil side, in the metropolitan cities, we have the city civil court, the court of small causes, and in the criminal side, we have the sessions court, metropolitan, and magistrates court. And at the district level, we have, in the civil side, the district court, the civil judge court, senior division and junior division. There are 2 divisions here. In the criminal side, we have sessions court and judicial magistrate court. With respect to the tribunals, we have the CAT, the Central Administrative Tribunal, income tax, motor accident claims, cooperatives, rent control, National Green Tribunal, which is also called the NGT. We also have the Telecom Regulatory Authority of India. No, actually, TRI is not a, it's a regulator. The Tribunal of TRI is TDACT, Telecom Dispute Settlement Appellate Tribunal. Then we have the industrial courts, both city and district level, and the labor courts. And finally, we have the labor courts. And I am not explaining anything about labor court, about family courts in this video. I have done 4 videos on the family justice system. If you have not checked it out, go check it out right now. And I'm sure your concepts will be very clear on that chapter. Okay, the high courts in India, it's the head of the judiciary at the state level. The first high courts dates back to 1862, when high courts were established in Bombay, Madras, and Calcutta by the Indian High Courts Act of 1861. Now, the high courts enjoy original jurisdiction in testamentary, matrimonial, and guardianship matters. Now, what is a testamentary matter? Testamentary matter, when it deals with something related to a will. A will is a formal expression of a person's desire to give his or her property to perhaps a husband, daughter, or son. Those are listed in a will of a person, very formally registered by a court, and those are the matters which are called testamentary. Then matrimonial matters related to marriage and guardianship matters with respect to having guardianship on a child. The High Courts also exercise a wide variety of writ jurisdiction, as I said, under Article 226, 32 for Supreme Court, 226 for the High Courts. And finally, it has a lot of supervisory powers on the subordinate courts, the district court, and it's also a court of record. All records of cases are maintained. The law declared by the court, it has to be followed by all the subordinate courts. The verdict of those of the high courts are to be followed by the subordinate courts. So these are the 3 points with respect to all the high courts in India. Now we come to three of the most important articles with regard to high courts in India. First of all, Article 214. 214, under this 214, the topic is High Court for states. In the language of this article, there shall be a High Court for each state. Okay, Article 215, the High Court has to be a court of record. Just as we discussed here, this provision is given by Article 215. It's one. And finally, Article 231, there has to be a common High Court for two or more states. Alright, so 231 states that a particular High Court can be used by more than one state. For example, Mizoram, Arunachal Pradesh, and Nagaland, the common high court of these states is in Guwahati in Assam. It's a common high court. Then in Punjab and Haryana, the Punjab and Haryana high court is there in Chandigarh. Goa doesn't have a specific high court. It falls under the Bombay High Court. And the government of India on 26 January 2013, it had established these three high courts, Meghalaya, Manipur, and Tripura. As a result, the number of high courts in India, it was increased from 21 to 24, and currently we have 25 high courts. And how are all these states having a common high court? So many instances are there. It is by Article 231 of the Indian Constitution. Now we look into the system of subordinate courts. First of all, the Munsif's Court, it's the lowest civil courts, and they have jurisdiction over claims from rupees 1000 to 5000. They are the lowest courts. Above the Munsif's Court, we have the subordinate judges, and above the subordinate judges, we have the district judges. District judges are the highest judicial authorities in the district below the high courts. And we have the district court since the enactment of CRPC, the Code of Criminal Procedure of 1973. Don't worry, guys, you will know in detail in the next video about this. It's very large. Now, the criminal trials are conducted by the judicial magistrates, except for in Jammu and Kashmir and Nagaland, where CRPC doesn't apply. Well, in Jammu and Kashmir, this Article 370 is now revoked, and CRPC does apply from now after 2020 or 21, I think. Now, Chief Judicial Magistrate, in shortcut I have written CJM, is the head of the criminal courts in the district. And Article 217 deals with the appointment of a High Court judge. Article 124 deals with the appointment of a Supreme Court judge, and Article 217 deals with the appointment of a High Court judge. You repeat it in your mind and you will know it. After that, we have the appointment, retirement, and removal of a subordinate court judges. In the civil side, the designations are district judge, additional district judge, and then we have the civil judge. In the criminal side, we have the sessions judge, the additional sessions judge, chief judicial magistrate CJM, as we discussed right here, and the judicial magistrate. The next question is that who appoints the judges of the subordinate courts? The answer is the governor, in consultation with the high court of that particular state, appoints the district judge. Article 233 provides the eligibility criteria for becoming the district judge, and it states that a person who is not already in a government service and who has at least 7 years of experience at the Bar Council of India, they're the central level. If any of you, I'm sure that many of you will become a lawyer one day, so all of you have to register with a bar. That's the Bar Council of India. A person who has to be appointed as a district judge has to have at least 7 years of experience at the bar. Then we have Article 234, which states that these appointments has to be made by the governor, and it lays down the rules that the State Public Service Commission has to be consulted, and the high court of that particular state has to be consulted in the appointment of any person to the judicial service of the state other than the district judge. Let's come to the civil process and functioning of the civil courts. First of all, the CPC is a procedural law, neither creates nor takes away any rights, and those are not criminal in nature. CPC, Code of Civil Procedure, it regulates the procedure that is involved in civil courts. It also regulates the functioning of the civil courts, and it also consolidates and amends the laws of the civil judicature. Those laws that are related to the civil process of law, those are amended and consolidated by the CPC, the Code of the Civil Procedure. It also lays down certain rules, like, just a second. Yes, it lays down certain rules like procedure of filing a case, powers of the courts. It passes different orders. Um, yes, it regulates the powers of the courts to pass different orders, and court fees and stamps that are involved in filing a case, rights of the parties. Now let me explain this to you. Now in any case, there is a plaintiff, the person who has filed the complaint, and a defendant against whom the case is being filed, the person who defends himself or herself against the allegation put forward by the plaintiff. So they are the parties, and the rights of both the plaintiff and defendant are also regulated by the Code of the Civil Procedure, or CPC. Then jurisdiction and parameters of the code, then specific rules for proceedings of a case, rights of appeals, review, or reference. These things are laid down, the rules of these things are laid down by CPC. Now, previously, in initial decades, in those time, the Uniform Code of Civil Procedure enacted in 1859 was followed in India. You can understand that then we lived under British Raj, and obviously the provisions perhaps were against the Indian interest, but now we follow the CPC, the Code of Civil Procedure, which was enacted in 1908. It was still enacted under the British Raj, but it was much more suited to the Indian needs. Now, CPC is divided into two parts. First of all, the main body, which consists of 158 sections, and the first schedule, second part, which consists of 51 orders. Now, 158 sections, it's substantive in nature, and substantive in nature as in it deals with the various theories. Okay, it lays down the general principles of the CPC, and it's fundamental. The body of CPC, which contains the sections, it cannot be amended except for the legislature. Legislature is very formal. As a result, only they have the power to amend the sections of CPC. While the first schedule, which consists of 51 orders, it's procedural in nature, and the method, manner, and mode of the civil proceedings, they are listed in the first schedule. They are basic and they can be amended by the high courts without taking recourse to the legislature. The next portion is named as the civil court structure. Well, the wrongs that are discussed in these courts, in these civil courts, are called civil wrongs. They deal with disputes pertaining to property, breach of contracts, wrongs with regard to transaction, and also minor omissions. Now, they can be subject to civil process, these wrongs, and the civil suits could be instituted by the aggrieved persons. The civil wrongs are redressed by injunctions. Injunctions are stop orders. You should stop doing something. That's provided by the court, or ordering a person to stop doing something. Those are injunctions. And the second way the civil wrongs are redressed are by paying damages or compensation to a person who has incurred a loss because of the irresponsible and careless behavior of the defendant. So let me tell you, who will get the money from here? Who will get the damages? Obviously, the plaintiff, the person who has filed the case, and who will pay the person who will pay the plaintiff? The defendant, the wrongdoer. I hope that concept is clear. And then we have to first proceed to the court of the lowest rank. and then subsequently move upwards. First the municip court, then the sub courts, then the district court, high court, and finally the supreme court. Now, the municip's court is competent if the value of the subject matter in the case is worth rupees 1 lakh or less. If it's more than that, if the value of the subject matter is more than 1 lakh, then this person has to go to the sub court. After the sub court, they have to go to the district court when the subject matter is up to rupees 2 lakh. And if it's more than 2 lakh, then the person has to go to a even formal level at the high court. Appeal shall lie to the Supreme Court if the High Court certifies that there is a substantial question of law of general importance, and if, in the opinion of the High Court, the question needs to be decided by the Supreme Court. Only in such cases will the cases go to the Supreme Court from the High Court. In general, the cases are settled in the High Court as the most authoritative institution. Then finally, congratulations that you have come to the last part of this video. We will look into the distinction between decree, judgment, and order. What is a decree? First of all, the articles. Very easy to remember. Decree, Article 2, Part 2. Judgment, Article 2, Part 9. And order, Article 33. Let me tell you one thing. Now, these articles from this portion are not asked. Well, some formal articles like 32 of the Supreme Court, writ jurisdiction, these things are asked, but this, I think, won't be asked. I must tell you, this won't be asked. But if you know this, you can write answers which are very rich in information, and you can impress your teacher. And since in term 2 you will be writing subjective answers, it's very important. Then, what is a decree? Now, a decree is a formal expression of an adjudication with regard to the court expressing it, and it's conclusively determining the rights of the parties with regard to any matter in controversy in the suit. It can be preliminary or final. And the section 144, there can be a declaration on the determination of the question, which is there in section 144. You don't have to remember this, so I have given this symbol. You can delete this part. You can simply leave this part. Now, a preliminary decree will be given if further proceedings have to be taken, but it must be drawn separately after the judgment. That's all about decree. In a nutshell, let me tell you, it's a formal expression determining the rights of the parties. If there is a question defined decree, you will write this. Formal expression determining the rights of the parties. Article 2, Part 2 of CPC. Then judgment, Article 2, Part 9 of CPC. It's a statement on grounds of a decree or order. So it's a statement. It's also a formal statement. You can write simply a statement with relation to a decree or an order. Now, it's necessary to give a statement in a judgment. It contemplates a stage prior or before reaching a decree or an order. The key words here is that it is necessary to give a statement in a judgment, while it's not necessary to give a statement in a decree or an order. And again, order is very simple because there is nothing much given in order. Order is section 33 of CPC, and order is it's a formal statement which is not a decree. What's an order? Order is a formal statement which is not a decree. That's it, nothing else. Okay, there are certain details given here. It's very basic and you have to just read it. There is nothing much to explain here. That's why I have not included this in the main notes. There are some common elements. It's clearly given in the textbook. You can read it from there. So it relates to a matter in controversy in a decree. It also relates to a matter in controversy. Decisions are given by a court of law. It's an adjudication of a court of law. It's a formal expression. Now the distinction between decree and judgment. It's not necessary for a judge to give a statement in a decree, whereas it's necessary in a judgment to give a statement. Okay, there are some common elements too. You can take a screenshot of this. Only this portion is relevant here. When both relates to matters in controversy, both are decisions given by a court, adjudications of a court of law. They are the formal expressions of a decision. And also we have the differences between the decree and the order. A decree can only be passed in suit as in a formal proceeding, and order, it originates from a suit. And that's it. You can just read this portion a little bit. Decree is an adjudication conclusively determining the rights of the parties, and order may or may not determine such rights. Decree may be preliminary or final, but there cannot be a preliminary order. Every decree is appealable unless otherwise provided, but every order is not appealable. Guys, this chapter has been a little big. My video is also a little big. In this video, we have already completed the first part, constitutional roles and impartiality, hierarchy of the courts, and the civil court structure. Completely, we have finished these three parts. We are left with just two parts, criminal courts and other courts. In the next video, I will be bringing more information on these two things. So I hope you liked this video. If you have any suggestion regarding some things that I can include in my videos or other things that I can provide you in the comments, please write anything that you want. And I hope you understood the chapter. Please do remember that you should maintain a chart on the articles that I have mentioned in this video, the important articles. Perhaps there are other things. And if you want a video on the boxes of the chapter, you can also write that in the comment. I will definitely try to make a video on the boxes. And also with regard to the extra things that are there in the family justice system, like children, juvenile justice, after I complete the syllabus of yours, I will try to complete those additional parts, because there is no harm in learning extra. And I am sure that there are certain extra things that also come in the internal exams. That's why I think you all are nervous about it. I will make the video on those extra parts too. Don't worry. So just ping me in the comments. Thank you so much for seeing the video. I hope you will like it, and please like, share, and subscribe. Thank you.